Welcome to This Plus podcast. Before we get started, we'd like to remind everyone that the information and opinions expressed by our speakers today are their own and do not necessarily represent the views of their employers or of Plus. The contents of these materials may not be relied upon as legal advice.
Hello, and welcome to the Employment Law Counselor podcast. I'm your host, Jeff Stewart, and today we're talking layoffs. It seems like you can't go more than a day or two without seeing news of a major layoff from a major U.S. company these days. Twitter, IBM, Goldman Sachs, DirecTV, Spotify, Microsoft, even Yankee Candle have announced major reductions in their workforce. Today, I've got my partner, Jim Anelli, here to talk about how we can avoid liability in layoffs situations. Jim, thank you for joining me today.
Yeah, thanks, Jeff. This is a timely topic. It's really critical, and it's important to employers. And as you can see, you've mentioned a number of companies, and particularly Twitter stands out for me as sort of a case study about layoffs, what they accomplish, how they should be done, and really the pitfalls associated with Twitter. I mean, you could see the unexpected consequences to layoffs that are not planned, where you just lose a tremendous amount of talent if it's not done properly. And we can talk about that later in the program. But, people have to think about layoffs, I think, in a different way from an employment setting. They need to focus not only on the jobs that are being lost, which are critical and sad, really. And they also need to focus on the employees that are left and how to handle those employees in a difficult situation.
I think I absolutely agree. And I think it's important to really discuss what we mean when we say layoff, because many times, while the word layoff implies a possibility of recall, when we're talking about these mass layoffs that companies are doing, they're really terminations. Wouldn't you agree?
Oh, absolutely. The term is probably antiquated and really does involve termination. And it can happen for a variety of reasons. And Twitter is probably a great example of that. It can happen because of a change in economic conditions. It can happen in a merger and acquisition where companies choose to downsize the size of their organization. And it can also happen in a voluntary way where employees are given the option to leave the company in exchange for a severance payment. So when we use the term layoff, we're really talking about a blanket term that covers a variety of different situations.
Absolutely. So let's take a typical scenario where a company forecasts difficult times and decides to reduce their size of its workforce by a certain number. Now, ideally, the company is going to identify how many people it needs to lay off or to terminate, determine whether that's going to be an involuntary or voluntary situation, come up with some standard to decide how people are going to be selected for layoff. And then they really have to look at a lot of potential pitfalls. Some of the pitfalls that I look at are there potential discrimination issues? Is there severance that we want to give? What are some of the issues that you look at, Jim, as potential pitfalls?
Sure. I think you started out talking about the planning process, and most companies do plan for layoffs and recognize there's a need to look at what the company is trying to accomplish. Sometimes it's as simple as cutting the overall size of an organization in order to maintain the viability of a company in difficult economic climates. Other times it's a strategic situation because the level of business has dropped, or there's been a change in the industry, maybe a change in technology that makes a particular segment of a company no longer viable in terms of competition. And so often it's a planning process, but there are also within that planning process various decisions that need to be made, such as, do you pay employees severance? How do you go about selecting the employees that will be subject to a layoff? Is it a departmental type review, or is it a broader type review? And on top of that, I think most importantly is the planning process needs to consider what employees will be needed to guide a company through difficult times post layoff, and what employees will be needed to successfully bring the company back to economic viability. And those are typically decisions that are made in conjunction with a board of directors and the C-suite of an organization, and revolve around what the organization is, their time frame is, and the severity of the issues facing them.
Yeah, and you mentioned the time frame there, and there's another area that we're going to get into it a little more in a few moments, which is, are there any statutory notice requirements? For example, the WARN Act, which provides a requirement of 60 days notice in a plant closure or a mass layoff situation. And those are defined by statute, but it's not as though you can say, hey, I want to lay off 150 people at this location and do it tomorrow. There might be notice requirements. Now, you may be able to do that and pay them in lieu of the notice, but it is something you need to be aware of. So I think it's best, why don't we talk about some of these potential pitfalls that you and I have both recognized in a little bit of detail here. First is that selection procedure of who's going to be laid off. I always tell my clients, Jim, and I'm sure you do the same, it's best to have some objective criteria. Most common is seniority. The people with the least seniority are the first ones to be let go. Now, that could be company-wide or it could be department-wide, depending on how you're doing things. But that's a nice objective standard to avoid potential discrimination claims.
Absolutely. Oftentimes, it's somewhat easy in deciding the scope or parameter of a layoff. Many times companies decide that they'll eliminate an entire department or a product or a service. And so all employees associated with a product, service, or department would be laid off. And so the contour is pretty clear and objective. Other times it is more of a selection process where the layoff is applicable to all employees in the organization, and management has been asked to come up with a cost savings of a particular number, and in doing so looks at potential candidates across the entire company. Inherent in that process is a selection process where management is selecting particular employees. Seniority is one way to do it. Performance is another way to do it. There are certainly other methods of reaching a determination of who will be subject to the layoff. The critical thing is to examine, though, whether your layoff process is having a disproportionate impact on protected classes. So if you're laying off, say, 100 workers, for example, company-wide, and 80% of them are women, even though they only make up 40% of the organization, then clearly it's having a disproportionate impact on women. And it's important to look at that and modify that selection process so that it matches up with the census of an organization in general. And that's one of the things that lawyers will do in overseeing the layoff process itself.
And another area to look for is specifically age discrimination, especially if, as you said, Jim, you're targeting, we need to get our budget down by a certain number, and we look at, the higher earners. Many times people who have been with the company longer and are paid more are also older. And if you're over the age of 40, you are in a protected class. And if your layoff is 70% people over the age of 40, we could have a potential age discrimination problem.
Yeah, this is actually becoming more of an issue, and here's why. With the advent of different types of communication platforms, like Slack and other instant messaging platforms, you have numerous conversations occurring among management officials. And what you can run into sometimes is you have someone who will make a stray comment about, well, we need to get rid of the dead wood, or we need to get rid of, certain individuals because they're not, active enough. They've slowed down too much. And you get these comments that really are indicative of age discrimination. And that's how plaintiffs prove their case. They introduce these comments to show the motivation behind the selection process. And it may well be that the company isn't intending at all to engage in age discrimination, but these stray comments made on these platforms can be really damaging to that process. And so that's one area that I really do see management really needing to buckle down, because when we get into these cases, we see some of these comments, the jury, as you might imagine, takes these comments really seriously, even though it may have been a comment that nobody really blessed. It was just kind of said out of the blue, and it wasn't something. That's why a management review of the ultimate impact of these types of layoffs is critical to disprove any type of stray comment that may have been made.
And
by management.
Given the technology today, those comments are now provable because they live forever in, a messaging app or something to that effect. Whereas a stray verbal comment, people can forget that they made. They're difficult to prove.
Absolutely.
So let's move to the second area, and that is the issue of severance. A lot of companies think, oh, well, if we just offer severance in exchange for a release, we're good. We don't have to worry about any potential lawsuits, etc. We should be fine. Do you find that to be the case, Jim?
Well, I think companies often review severance for a variety of different reasons. So in some instances, they're looking at severance because they're obligated to provide severance under, say, a WARN Act or other state mini WARN Acts. Alternatively, though, many of my clients, for example, will look at, concepts of fairness, and they kind of recognize that many of these employees aren't at fault, for the layoff itself. And in terms of equity, they want to provide a certain amount of severance to these workers, but typically it's in exchange for a release. It's fairly common these days to provide severance in layoffs and to request a release. I would say the vast majority of employers do request a release in exchange for severance. The types of severance that are paid can often vary depending upon both seniority, the employee's position within the company, and also for those companies that are unionized, there may be a specific provision to pay severance of a specific amount, under a collective bargaining agreement. But I do think that in answer to your question, having a severance agreement certainly would prevent, most claims from being filed with respect to the individual employee. And so that's why I think employers, try to obtain those agreements. There's always going to be employees that, for whatever reason, refuse to sign a severance agreement, or alternatively get an attorney to negotiate severance. My experience in this area has been that very few employers in a group layoff situation will get into negotiations with an individual employee that would be different than what has been proposed for the group.
Right. And I agree with you. I think the one thing that you need to be sure of as a company is, you use an example that you may have severance due to the WARN Act. So in lieu of 60 days notice, we're required to give 60 days of pay. If we want a general release, we have to give more than the minimum that the statute requires. So maybe we give, 90 days of pay. but there has to be more than what someone is required to be paid in order for the release to have consideration.
That's right. In fact, that is a common mistake that I see all the time where a company has, say, a severance policy or severance program, and the release agreement or severance agreement that's provided to the employee recites that it's paying the amount of severance that the company would otherwise have to pay as consideration for the agreement. In those situations, there is no consideration for the agreement, and therefore, even if the agreement is executed, it's probably not enforceable unless there's some other additional consideration. And the bar is not particularly high. You can offer almost anything else, and it generally will be deemed additional consideration. But despite that fact, I see these types of agreements from time to time where there really isn't sufficient consideration because the company hasn't done anything else other than agreeing to pay what they're already legally required to pay.
Yeah. Now, let's go to the next pitfall, and it's one that people may not think of as a pitfall as much, and that is, do you have employees work after they've been notified that they are going to be laid off or let go? And my position is many more problems can occur if you allow an employee to continue working after they know they are going to be let go. Do you see the same thing, Jim?
I do. I think in general, you're right. I think that most employers will basically ask the employees, not to work upon providing notice of termination in a layoff. However, I have to say that attorneys think about liability and they think about the law, whereas many times our clients are business people and they have to confront the practicalities of doing business. And this is actually one example where there can be a pretty significant divergence. So there may well be times when a company is simply not in a position to say 300 or 400 employees, we'll provide a notice of termination and pay you severance for the next 60 days and you don't have to come into work, because there is a need to complete projects. There is a need to complete different types of contract work. There's a need to maintain some stability in the organization. And so what I've seen employers do, and it's kind of interesting, is they combine the notice of the layoff with a bonus program if the employees stay through the entire program. And, that's an example of companies that don't have the ability to simply say, don't come into work. There are other times, particularly I would say in smaller layoffs, where employees can be given notice and they're immediately asked to leave the office. I think, quite frankly, that has to be done in a way that gives the employees the opportunity to say goodbye to each other. It's, as you might imagine, these are always difficult circumstances. And I think if it's done in the right manner, you'll actually cut down on the number of claims later on. But I do think there's a divergence here and in some industries and some businesses. But Jeff, I agree with you. I think in general, it's probably a good idea. I think it's really up to management to make that determination for itself and its organization.
And some of the areas of potential liability or problems that I have seen when someone is notified that they're going to be let go, but they continue to work, are areas like, all of a sudden they have a workers' comp issue. They get hurt at work, and now we're dealing with that workers' comp issue for 5 years or longer.
Yeah, another issue is the employees are out looking for jobs. And
absolutely.
So they know they're going to be laid off in, say, 6 to 8 weeks, just by way of an example. And they basically look at it as, I've got to get a job in the next 6 to 8 weeks. I got to go out and interview. I got to brush up my resume. I got to talk to people and talk to friends. And they're sort of there in the sense that they're still employed during some particular time frame. They're still coming into work, but their interest and their focus has moved on to the next job.
And that actually goes to a couple of other areas that I see as potential problems there if someone continues to work is what kind of communications are they having with the company's customers? Where if they are communicating with vendors, customers, etc., are they speaking well of the company, or are they letting them know, hey, I'm getting let go and I'm upset A, B, C, or D? Another area is frankly theft. Seeing people come and take files, take various things from the office because they know they're gone. It may not be the first thing you think of, but these are people who feel many times wronged by this layoff decision.
Right. And I think you see that particularly in the professional services area, of the economy, where you've got individuals that have clients, and the first question is, okay, I'm going to be laid off from this particular company. Can I take my clients with me? Can I move on and, wherever I go, take those clients, take that business with me to another company? And so it definitely, depending upon the industry and the types of employees we're talking about, can be a significant factor in deciding, well, maybe I don't want these employees to be in a situation where they're, basically working with clients that they may seek to take in the future to a new employer. And so I may decide it's too much of a risk to allow that individual. It can even be the case, and I've seen this before, where for some groups of employees, management has decided that they don't need to come into work and that they'll initiate the termination immediately. And then for others, they've decided, not to do it, particularly in a fairly large type of group layoff situation.
Agreed. All right, so let's talk about the last, I'll say, pitfall area that we identified earlier, and that is the WARN Act and some statutory rules that may impact a layoff, generally a large layoff. Now, I'll stay right now, we could do an entire podcast on the WARN Act. That's not what this is intended to be. But just as an overview, the WARN Act, that is implicated when an employer closes a facility that affects 50 or more employees, when there is a layoff of 500 or more employees at a single site, or if you lay off 50 or more, that constitutes at least 33% of your workforce. And the WARN Act requires 60 days advance notice or pay in lieu of that notice. Now, in addition to the federal WARN Act, many states have enacted what I'll call mini WARN Acts that usually lower those thresholds to smaller layoffs that are implicated under federal rule. And some require even more notice. And I think the most important thing is to know what state you're in and to look, what are the rules? Would you agree with that, Jim?
Oh, very much so. I mean, the Federal WARN Act is, I think, coming up on its 30th anniversary. And I will say that it definitely is probably one of the most misapplied statutes by employers. It's a complicated statute, and what's happened over the last few decades is that the courts have added on to the statute a lot of triggers that employers can miss in doing a mass layoff. And as a result, they unintentionally trigger WARN, and it can be a massive amount of exposure if the layoff is large enough. In addition to that, as a background, you've mentioned the state, they call them mini WARN Acts, but I will tell you that this is an area that really has been ramping up. And I think this could well be the year where we start to see many more states start adopting state WARN Acts. And it's complicated because a lot of large employers do work in many states, and these these statutes can be quite different. So, for example, in New York and Tennessee, there's a 50 employee requirement to be covered by the state Mini Warrant Act. It's not 100 employees like the federal act. And so many small employers are governed by New York and Tennessee's, Mini Warrant Act, and they probably don't realize it. On top of that, New Jersey has just enacted a amendment to its Warrant Act effective this April 2023, which provides for severance even if notice is given to employees covered by the layoff, if it's 50 or more employees and the employer has 100 employees nationally within the U.S. And, I was working with one client earlier this week, and the amount of severance that we calculated was $1.5 million for a relatively small employer, just over 100 employees. And so, as you can see, these state acts are going to be critical in deciding where you have layoffs in that jurisdiction, how to structure them. Another aspect of this, of course, is where you have employees working remotely, and the issue becomes where do these employees reside in connection with these types of warrant acts. In the federal act, it may not be all that important, but in some of these state acts, it may well be an interesting question. We're currently dealing with this on several levels, where if you have a whole workforce that's reporting to, say, a headquarters in New Jersey, are they New Jersey employees for the purpose of the New Jersey Warrant Act, or are they employees of the state where they're working at home, in their house? And you're going to see more cases on this particular topic, but that's just symptomatic, I think, of warrant in general, is that you always have cases that come down from the courts to sort of explain and expand some of these Warrant Act considerations. And so, for sure, anybody doing a mass layoff is going to have to pay really careful attention to the states that are involved and really walk through it. One of the issues in this area, for example, is that the states are now saying that independent contractors can be deemed employees if they don't meet the state test for an independent contractor. And so you could have a situation where companies may have 30 to 40 independent contractors on staff and may have 70 employees and think that they're not covered by a Warrant Act. And yet, if you include the independent contractors, if they can't meet the state's standards, then they clearly are covered. And that's another issue that's out there that is currently being addressed. This is all stuff that's on the cutting edge, but it's out there right now.
And I think in the current environment, you're going to see more state legislatures pass mini warrant acts or expand theirs because they're seeing large layoffs and they want to make sure that employees, frankly, are protected in some way. And jobs
you're actually going to start seeing not only states, but cities. Philadelphia has a Warrant Act. District of Columbia has a Warrant Act. I wouldn't be surprised to see a number of other states other cities adopt Warrant Acts as well as, states. So you could have a situation where you not only need to look at the state, but you need to look at the city that the layoff is occurring in.
All right. So with that, Jim, as you know, I like to give our listeners a few takeaways from our discussion here today. Do you have a takeaway to give to our listeners?
Yeah, I have two takeaways. I think the first is layoffs are complex. They should be done with planning, and they should be done in consultation with management. And I think the first thing that really should be discussed is what is the overall goal for the organization and what is in its best interest as an organization, and how will the layoffs be perceived by the employees who are remaining? How will the employees who are remaining be treated? What types of communications will there be with the employees who remain? And what is the overall goal of the organization post termination and post-layoff. Sometimes these types of discussions don't happen, and things can go kind of off the tracks, and you can wind up losing a tremendous amount of talent in an environment where it's very difficult to obtain talent. And so I think it's, most companies that do this well are very pragmatic in how they view this. And that would be my takeaway.
Mine would be that layoffs done poorly can lead to a tremendous amount of potential liability, but it's really the companies themselves that have control over this. As Jim said, planning, taking your time and figuring out what is my goal, how do I get there, and let's do it carefully and make sure we are communicating internally with our management team, externally with legal counsel to make sure we know what laws may be implicated in order to do it well, and then communicating with your people so that they understand how they were selected or what the business reason is behind it. The more people understand the why, the less likely the claims will come back to you. So with that, I'd like to thank you for listening to the Employment Law Counselor podcast. On behalf of Jim Anelli, I'm Jeff Stewart. Thank you, and we'll talk to you again soon.
Thank you for listening to this Plus podcast. If you have ideas you'd like considered for future podcasts, visit the Plus website and complete the Plus content idea form.